even to clear Magu for, what is it called, for confirmation. You are fighting the head and you're asking him to clear you. These are strategies suggested by advisory committee. That's the point I am saying. That's the allegation I'm giving on the basis of fact.
Well, the advisory committee might say that they were just speaking in defense of government.
Well,
maybe they also saw themselves as people who need to defend government actions when it comes to the fight against corruption.
And suddenly they are no longer in defense of government, right?
But they are saying that government might need to go back to the drawing board.
So why are they just waking up now to do the blame game?
Let me ask you this.
Right.
They are suggesting that they believe that the proof of burden, the burden of proof, beg your pardon, should change. They believe that in cases of corruption, it should move to the defendant.
This is not the first time criminal trial is conducted in Nigeria. This is not the first time conviction is secured. The inability of the prosecution to achieve success cannot be a ground to call for a change of burden of proof. The world over, prosecution have been proven. James Ibori was convicted. There are lots of cases in America, cases even here in Nigeria, high-profile cases for which conviction was secured. Because a thorough investigation was done, a proper prosecution approach was taken.
Mr. Bwala, you're very aware of how much it takes to conduct a very successful prosecution in a case where things have been entrenched. Let's talk about even the James Ibori case, where in the United Kingdom, when they documented how much it took them to investigate. They were thinking of confiscating certain of his properties so that they can recoup the cost it took them to prosecute.
Yeah, something in the range of whether 12 to 15 million pounds. But that is an isolated case. That's an isolated case. The intel community, and that's another thing. There is no cooperation between the EFCC and the DSS. And the DSS ought to be the very good supportive element of EFCC. But now, they are in their findings, finding fault with the EFCC chair. That's the reason why the government cannot close its eyes from that allegation, because there has to be a cooperation before you can succeed. Now, look at it this way, Mark. In our Nigeria of today, Nigeria is not as sophisticated in advance fee fraud as countries that you are mentioning, for which it will be difficult for you to get these persons. We have advised from the commencement of this administration, explore plea bargain. For reasons we don't know, they don't hear. Or maybe they have applied in isolated cases. Criminal trial, the burden is not easy. So if you know the burden is not easy to prove it, you suggest plea bargain, because the whole idea is anti-corruption fight, security and economic recovery.
But won't the people kick? I mean, we've seen plea bargain implemented in this country, and some people say it sucks the way it's implemented.
The reason is because people do not have a thorough idea of plea bargain. Plea bargain does not mean you get the money from someone and ask him to go.
Well, we'll take a moment and we'll ask you to explain a bit more. If we were to employ plea bargain, how will it work? In just a moment, please stay with us. Mr. Daniel Bwala is still with us. He's a legal practitioner and also a member of Lincoln's Inn in beg your pardon, in London. Well, just before we went on break, you were talking about the implementation of plea bargain. Can you shed a bit more light in terms of how it should be implemented? Because when people think of plea bargain, they remember the case of Mr. Lucky Gbenedion, how the plea bargaining was implemented in his case, and if they say if this is how it's been done, then perhaps that's not the way to go. You see, the Administration of Criminal Justice Act is clear on the plea bargain. In fact, the court plays a role in guarding plea bargain to be sure that the prosecution, for example, is not compromised in the process. Because there is this assumption that somebody who is involved in corruption, for example, if he's reaching a plea bargain with the government agencies, he can bribe them privately, and then they will agree to what is probably stupendous, and then he will be let off the hook. But the Administration of Criminal Justice Act says whatever the government, the prosecutor, or the prosecution proposes, and the defense is given, the court will also have to weigh and see whether it is clear and does not offend public policy, does not offend certain parameters. Now, the question is, have the government approached these individuals for that? Before you can succeed in the proposal for plea bargain, you have to have overwhelming evidence against that person. Because if I know that with the evidence on ground, I will have no option but to take plea bargain, I will quickly ask for plea bargain. Well, let us quickly then go to Lagos and take some questions.
Mr. Daniel, we do hear your submissions, except that on a lighter note, you don't seem happy with Mourinho. You say this Mourinho tactics, but the chap won Europa League, and we don't want Man U fans to besiege our Twitter handle. But then, if, as presently constituted now, the Administration of Criminal Justice System, Are you saying that if certain other persons were handling some of those cases, will there be results? Could you give us an example?
Right. Like when I explain a criminal trial, the burden of proof, which lies, of course, on the prosecution. If, for example, there is, because, and I have a degree of sympathy for even the prosecutors, the lawyers who prosecute the case, because they work on the evidence gathered by the agencies, the intel agencies, that is the result of the investigation. Investigation is a foundation for criminal trial. If the investigation is poor, I can guarantee you that the criminal trial will fail. The reason is because in criminal trial, the burden is beyond reasonable doubt, and you have to establish all. If you charge somebody with 10 offenses, in the charge sheet, the element constituting 1, 2, 3 up to the 10th offense has to be established. Anyone that you fail to do that in the charge will go down. And for you to be able to succeed, you have to first of all have facts, have documents, and have witnesses. The witnesses must be credible witnesses. The witnesses must be individuals that will give testimony that the court will believe in them. What we have seen, you ask for example, in recent past, especially with respect to the decision of the court regarding this criminal trial, a specific mention of the character and testimony of the witnesses. Now, the prosecution ought to get credible witnesses. And then, secondly, and very important, Chamberlain, you see, when you look at the statement of somebody from Ministry of Justice, I can't recall his name, but who always accuses the judges anytime they don't get something in the court. That is what I mean by Mourinho tactics. Mourinho tactics is, if he is not winning, then somebody is at fault. When he wins, then it doesn't matter how he wins it. And that is wrong for our polity. There must be some blame. In fact, most of the blame should be on the prosecution. So if you don't do your work, there is just no way you can succeed in that. That is my opinion.
When you made mention of, you proffered some solutions to this corruption war that we're facing in this country. You did say that PACAC should be dissolved. You did say that replace the EFCC boss, and also you said that perhaps the Attorney General of the Federation should also be replaced. What impact will that have on the anti-graft war?
Very important, and thank you for that question. And here is the issue. Here is my response. Number one, the anti-corruption fight is becoming unpopular because of the role that these three players are playing in this prosecution war. And let me start with PACA. PACA, first time in the history of our democracy, we're seeing a presidential advisory commission with the good intention that the president had. He said, I needed people with the knowledge of the law to advise me on that. Now, they have been advising the government. There is no way we will know whether the government implements their advice other than the fact that now they defend every act of the government. They don't even wait for the Attorney General to go ahead and defend that. And in the past, the Attorney General has been the instrument for either defending the government or admitting the wrongdoing of the government. So they have been doing that. And there is the suggestion it is a product of their advice. And that tactics is not working. Because for the first time, we have seen the homes of judges raided, apart from casting aspersion on the judge. I believe there is corruption in the judiciary. But everybody is not corrupt. And the court in Lagos, court in Abuja, court in medical courts everywhere are corrupt. So that's the part on PACA. On the office of the Attorney General, the Attorney General is not vocal and vociferous on this campaign. He seems slow and quiet, and some people say he's playing to the gallery. There is somebody in his ministry, I think something Obla, who is more vocal and vociferous, but unfortunately, passing out unfortunate comments and statements and casting aspersion on the judges, which is very, very wrong. Now, that is the office of the Attorney General. The entirety of the criminal trial should rest in his office. Even the EFCC is under him. The Attorney General, by the Constitution, can institute, can prosecute, and can continue, and then can discontinue criminal trial. So look at the assessment. If he is not vocal and vociferous and active and proactive, then there is a tendency for him to be reassigned elsewhere. And then the last one is the chair of the EFCC. Now, he's a good man whom I have defended for over 2 years. But you see, circumstances surrounding his non-confirmation, the role played by the government, has created a disaffection in the society. So much so that the goodwill he enjoys is waning down. Now, every step he takes is read into different meaning. It is only natural in the circumstance. for you to retrieve him and give him some other job and then bring someone so this thing can go, because it's not about person, it's about institution. And you must have heard me over a period of time saying defending him, defending him, defending him. And now that the results are not showing, it is time for reappraisal and review of the strategy.
Well, definitely it's a fine place to leave it. We have to thank you most kindly, Mr. Daniel Bwala. He's a member of, beg your pardon, he's a legal practitioner and also a member of Lincoln's Inn in London. The Sunrise Daily will continue about now as we go over to Lagos with Chamberlain and Gimba.